Hi, everybody. Just letting you all get logged on. Bear with me. Got my witch hat on. I got my witch hat on. Feels kind of funky today, but okay. How's everybody doing? Hey, hey, hey. My tripod broke this morning. So I am now needing to get a new tripod. It fell apart. I've had this tripod forever. Thanks to you guys, because one of you sent it to me. You know who you are. My tripod broke today. I think I've had this one for like 3 years now, and I use it every week. I use it often. Sometimes it's a weapon. It could be anything, right? Sorry, this feels funky on my head. Happy Halloween, everybody. All right, can you guys hear me? Because nobody said anything yet. Nobody's telling me I look
Yes,
ridiculous.
we hear you. I hear
Okay,
you.
hi.
This is April. How are you?
Hi, April. Hi.
I hear you. I like your hat. This is Sydney.
I'm the woodland witch.
I'm
Hey, I got to do something for Halloween, you know? All right. We got some things in the works going on. Hello, witches.
Hello.
I got a new thing too. It's Widget's Way, W-A-Y. Why? Because we don't look good in orange. Sorry, I thought it was cute. Just want to talk to you guys again about the things that we have coming at us. It's okay, Bill. See, we still love you. We have new laws coming, so I'm going to readdress them right now. As it sits currently, landlords need to landlords across the state of California are now required as of January 1st to supply all appliances to residents in residential dwellings. What did I just say? You guys got to put in refrigerators and ovens and stoves. Okay. It is a requirement. As of January 1st, we are responsible to provide the tenants with a refrigerator. For those of us that have existing tenants, I am working on an addendum with AGLA. It should be out probably mid-November, I'm guessing. Okay. That way it gives you plenty of time to get it signed by the tenant prior to January 1, stating that at this time they'd like to use their own refrigerator, stove, oven, whatever it is, so that you have the addendum on file. Okay. And then if their refrigerator goes out, you're going to have to replace it, but you have to do it anyway. So my way is an easy way to put a Band-Aid on the expense until it's actually implemented. An addendum is definitely what needs to be on file, okay? The tenant must sign this stating that at this time they want to use their own, okay? Otherwise, you have to provide it. I'm trying to save you from having to go buy a refrigerator for all of your rental homes. It does say when leases renew, okay? For those of us that are on a month-to-month, the lease renews on January 1st, and we accept the rent as a new monthly tenancy, okay? So it's not just on a lease renewal. Remember, if you're on a month-to-month, that renewal renews every month. So with that said, on or before January 1st, you need to have addendums signed for all tenants that would like to use their own refrigerator or their own stove and oven. And going forward, we're just going to have to provide all the appliances. I will put the addendum on my website. It'll also be on AGLA's website. I'm working diligently on it. I have 2 attorneys that are looking it over right now. The third one already approved it. But here's what I learned, okay? My brain works in weird ways. When I have a very detailed, in-depth question that I need the answer to from an attorney, I will ask 5 of them and then take majority of rule. Why is that? Because attorneys will only give you an answer based on what they are willing to argue. Oh, okay, that makes sense. If they're not willing to argue it, they may give you a bad answer or does this make sense to you? So what I tried to do is not listen to one attorney or 2 attorneys, but I'll go talk to 5 of them and get all their opinions. And then majority of those 5-6 attorneys I've talked to of whatever they say. I know it's a weird way to do things, but it's how I've realized to work with attorneys and get the answers that we need to make our process and procedure flow well. So I got ways to work with them. Remember, they work a courtroom. They don't work a property management company. They don't work investment property. They work a courtroom. This wobbly, gobbly thing is driving me crazy. That's not a drive. It's a short putt. Gavin Newsom passed this bill, I believe. I know. Okay, hang on. Let me catch up. Hello, witches. I missed a few meetings where Bill 628 was discussed. Could you please clarify? Are all owners now required to provide a stove and refrigerator even for single family residences? Yes, all residential dwellings within the state. Also, does this requirement apply to new tenants starting their tenancy in January or only when existing leases are renewed next year? It's when any rental is renewed. So if they're on a 1-year term right now, in the middle of their term, when it renews, you need them to sign the addendum stating that they want to use their own. Okay? That would probably be the best business practice. If they are on a month-to-month tenancy, then that month-to-month renews at the end of every month. So you want to have it on file before January 1, okay? Patty, can we give a 30-day notice to cure for a tenant with hoarding junk on their patio and inside their home? Yes, but we're not calling it hoarding, Scott. Hoarding is a medical condition diagnosed by a doctor. They are pack rats. Okay? I'm trying to retrain your brain because you don't want to yell out, they're a hoarder in the middle of a jury trial. And then the opposing counsel is going to ask you when you became a medical professional or when were you aware of the tenant's diagnosis? And then you're like, oh God. So you got to be careful. Okay. They're not hoarders. They are pack rats. Okay. And yes, you can give a 30-day to cure or quit. You could do a 3-day cure or quit on it.
Okay.
What city is it in?
Rancho Cucamonga.
I do a 3-day cure or quit to remove their personal belongings from view of the public
Mm-hmm.
because it's on their balcony, right?
Yes.
And then I talk to them about cleanliness in their home and clutter.
Don't do a 30-day to cure about inside of the home, only the outside?
No, give them a 3-day on both. Why do you keep saying a 30-day? I'm confused.
Okay, so the owner wanted us to give them 30 days, but if you say 3,
Okay, just hear me out, okay?
mm-hmm.
The notice you serve is a 3-day notice to cure or quit.
Okay.
Anytime after that notice, you could serve another one, but you need to understand, and the owner needs to understand that once you serve that notice, you cannot accept the rent. Example, if I serve that today, I can't accept the rent on November 1st, or I'm voiding my own notice.
Okay. I know what to do. Thank you.
Okay, give them more time. You're fine, but serve a 3-day and just give more time on it.
Okay. Thank you.
Would be my thing. No problem, anytime. Erica from Roadrunner, are there any laws I should be aware of ending an elderly tenant's tenancy due to non-payment of rent covered by the TPA? Is their age a factor I should consider? No, absolutely not. Age, sex, marital status, race, color, size, attitude, disability, don't matter. Okay, if they don't pay the rent, they didn't pay the rent, serve them a notice. They are not protected unless they're in LA County and they're scared of ICE. Okay, that's the only protections for non-payment of rent. You shouldn't allow someone with a disability to have special treatment. It's actually a fair housing violation. So if they're elderly or disabled and they didn't pay the rent, serve them a notice like you would anyone else, or you're discriminating. Okay? I hope that's clicking and making sense for you. But don't let somebody that, oh, they're disabled, oh, they have kids. Don't let your emotions get involved. Put up a block wall to that. Okay. Look at it this way. Okay. And hear me out. And Widget's going to be funny right now. So everybody pay attention. Sorry. In the event you're dealing with someone with a disability, we are not allowed to ask them about their disability, talk about their disability, confront them about their disability, how they got disabled, what disabilities they have. It's all a protected class, right? They're protected. We can't treat them any differently. We can't. Keyword, we can't treat them any differently. If I don't pay my rent in 3 days, are you going to serve me a notice? Yes, you are. Yes, you are. It doesn't matter if I'm disabled or anything else, right? So let's just do business. Oh, no. No, you didn't. So you guys want to know something really bad? Okay, you guys know why we're laughing right now, okay? Because Roadrunner Realty just read my shirt. Can you see it? It's Halloween. It's the whole thing going, right? So my very first employee meeting at AGLA, I accidentally wore my shirt and it was a Zoom meeting, but it says hooker across the front and it has a whole bunch of fish hooks on it. Okay. And I wore it to the AGLA, my very first employee meeting with AGLA. I wear that shirt in the Zoom meeting. And one of the girls, Mona, says, "Hey, Patti, nice shirt." I looked down, I was like, oh God. And then I got a piece of paper and put it right here. And just the H and the R were sticking out. So it looked like human resources. Leave it up to me to be offensive. Sorry. Hey, Patti, I have a tenant in Montebello, LA County, that I believe is renting rooms and hasn't paid this month's rent. Should I start the eviction or notify him about having extra tenants coming and going? You should do both. I mean, let me explain something, okay? And just hear me out, okay? Sometimes we turn a blind eye to one of the ducks that are out of line. Example, I know for a fact one of my tenants doesn't have their dog licensed. I know for a fact. They're not licensed in the city. Our rental agreements all require that the resident in possession follow all city and governmental laws. Hence being, the tenant should have their dog registered with the city, right? It's part of the law. But I may file that away in my arsenal of things that are out of line. It isn't something I want to evict from or pound my fist in their face for. But in the event we have a conglomeration, we have something that breaks the straw, I now have several ducks that are out of alignment I can throw at them all at once. Oh, okay, I get it, Patti. Some things we don't want to turn a blind eye to. Making sure the tenant has insurance and that it's current is something we do not want to turn a blind eye to. The fact that their dog isn't licensed in the city where they reside, probably something we're going to push to the side and keep under our wing in the event that we need it. Because when I come and attack, I attack with everything. I don't serve you a cure or quit for one thing. I serve you a cure or quit for 15 things. You have 3 days. Good luck. Okay, but that's the mindset of, it's almost like we put a little nesting doll up here in the corner and mark it dogs unlicensed. And then we take another little nesting doll and put it up there and say, there's a broken window. And then we take another little nesting doll. You get what I'm saying? And then when they don't pay the rent, we say, you have unauthorized occupants, your pet isn't licensed with the city. We throw everything at them at once. Attack! Okay, that's kind of how we do that. Some things we turn a blind eye to, some things we don't. So this is what I would do. I would attack, okay? You're in LA County. It depends on the city you're in, how much time you have to give. LARSO requires 30-day notice for unauthorized pets or unauthorized people. Okay. Pets and people take 30 days in Larceau. Everywhere else, to the best of my knowledge, is a 3-day curable breach of covenant for unauthorized pets, unauthorized people, and non-payment of rent. So I would say, hey, your rent hasn't been paid. You have unauthorized people, but you're going to have dates, times, and witnesses on the curable. You guys need to know that when you're doing a curable breach of covenant, if it is lacking dates, times, and witnesses, it is not in compliance with the civil process, 1161.2, I believe. So we got to make sure that everything's in compliance with civil process in order for it to be successful later. So a curable breach of covenant notice is very important that it has dates, times, and witnesses. How I would write that would be, you are in a material breach of your rental agreement dated, whatever date that was dated, in regards to page 4, paragraph 13, and then I'd quote it, whatever that said, okay? And then I would say, on January 3rd of 2015, it was noticed by the property manager and their name, so now I have a date, at 3 p.m. that you had unauthorized occupants within your unit. Date, time, witness. How do they correct it? Remove the unauthorized occupants within 3 days. Okay, so when you do a curable notice, it's got to be very in-depth with a lot of information. And honestly, if you're going to go to court over something on a curable, you want to be talking to your legal counsel at hello, because you don't want to waste time when you're serving the curables. Let me give you an example. Some cities, to be successful in court, in some cities, require you to give them more than one curable. Well, did you notify them more than once to cure it? Example, San Bernardino, Riverside, they usually one and done. One curable and then the quit comes, okay? With a 24-hour in between. In some cities, you have to serve a curable 4, 5, 6 times before you do that notice to quit. That means you're serving a 3-day cure or quit. You're doing a 24-hour notice. They didn't fix it. It's a second request, a cure or quit again. Another 24-hour notice, a third request on the cure or quit with new dates, times, and witnesses, because every time you go there, it hasn't been corrected, right? And you're going to put that it's ongoing on each one of these new notices. And then when the attorney finally says we can do the notice to quit, yeah, we're there. But if you did 4 curables at 3 days a piece plus a 24-hour in between, we're up at 15 days now of just diligently serving notices. I mean, it's aggressive. That's the word I'm looking for. But yes, you can absolutely go after them. No problem, Gabby. Anybody else have anything that they want to talk about? The things that I see coming at us are the appliance law. Obviously, that's the biggest one that I see that we're going to have as being challenging. Patty, can you recommend what I should do for a hold harmless agreement? That's a very convoluted question. Hold harmless against what? Anything?
Hey,
Let me ask. Go ahead.
Okay, so it's a mold situation, and the owner wants me. The tenant's okay with me doing all the work, but the owner wants to be released from any liability. So she asked her if she's willing to, the tenant willing to sign a hold harmless agreement because she wants to stay in the house while we're remediating. And she said, yeah, I don't mind signing that. So I'm trying to find a hold harmless agreement.
Hold on, my brain is firing off. The internet is not frozen. Widget is, okay? Give me a minute. There's not a harmless on mold. Mold isn't turned into AQMD, so it doesn't become public record. Only lead-based paint becomes public record. So I don't have to worry about that part of it. So I can shut that out of my brain. Sorry, I'm going to talk this out loud so you can see how my brain works, okay? So mold only needs to be disclosed and remedied upon notification. They're hindering you remedying it on notification because they don't want to vacate. You're saying that they don't have to vacate and it's okay not to vacate. So because they don't need to vacate, we may not need to credit them the full amount of the rent unless you're doing it as a courtesy.
I am. I'm giving him a month of rent. Month of November is going to be free, and
Okay.
in exchange for her signing the hold harmless agreement.
Okay. How bad is the mold?
It's contained in the bathroom, and we've
Oh,
got the zipper. We got the zipper plastic up, and it's
okay. And what caused the infestation?
A leak from the shower into the framing around the shower.
Would the tenant have known of the leak?
No, and neither would I.
I'm trying to, you know me, I'm searching for a way to try to pin the expense on the tenant because isn't that what we do? But no, I got you. Honestly, I just have her put an email. You're not going to get a hold harmless out of it, I don't think. And I'm waiting to see if Chris pipes in. Sometimes he'll give us his opinion. You can call and ask an attorney to prepare a hold harmless for you, but the reality is they're asking to stay even though you offered. I don't think there's going to be an issue, especially because it's just contained in the bathroom.
Yeah, my client's attorney is out of the country, so we can't get him to write it up.
Your client is what?
My client's attorney, her personal attorney, is out of the country, so I can't ask her attorney to write up the hold harmless.
Yeah, you can call your eviction attorney, call your real estate attorney. They can write a hold harmless for you. Dennis Block, Fast Evict, any of them.
Yeah, I that was my last thing. I looked on CAA and I don't see anything on there on CAA.
Hold harmless in my experience is very specific to the event.
Okay. All right.
Does that make sense?
It does.
Like there's not a generic hold harmless that could be used everywhere. Usually a hold harmless is you're specifying that event and making it so you can't hold anything against me. I could be wrong, but I would talk to legal counsel. And an eviction attorney has done this before. I know because Fast Evict used to do mold disclosures, hold harmless, things of that nature.
Perfect. Thank you.
No worries, no worries. Okay, I see questions coming. Patty, see above. Okay, I missed Val somewhere. I just read your shirt. Roadrunner. Val, another rat pack situation. Pack rat, not rat pack. Those were crooners back in the 50s, I think. I have a leak in a house. The hoarder would not let my guy go in to fix the leaky toilet. She told my guy her toilet had been leaking. I pay the water, so I knew something was wrong. The tenant said my guy could come this Friday at noon. I plan to post a 24-hour notice to enter just in case she bails. Is it okay to serve a 24-hour notice today to enter for a Friday entry? Yes. And if she fails to allow entry or says you can't come in, you can call the police and force that she allow you entry because you have a right as a landlord to preserve your real property under statute. So it's California Civil Code 1954, and you have a right to preserve your real property. And because you have a water leak that's costing you monetary damages, you have a right to fix that. Whether she wants to let you in or not, call the cops. Okay? I got Val. Patty, we have an owner, Roadrunner, pay attention. We have an owner with a single family home in San Bernardino not covered by the TPA. Back in February, we served the tenants with a 60-day notice to vacate because the owner wanted to sell the house. They were paying $1,750. Fast forward to June, she listed the house for sale, almost had a sale, but it fell through, and then takes it down in August. She came back to us in September, and I haven't sold the house and I want to put it back up for rent. She posted the house for rent. Hang on. Let me go back to where we are with AB 1482. San Bernardino County, no covered by the TPA. So it's a SFR exempt from the TPA. And now she wants to put it back on the market. Okay, we posted the house for rent at 2,800, and the previous tenants are now wanting the owners to pay them for moving costs and the stress of being displaced from the house. Do they have a leg to stand on? Were you exempt from AB 1482? And you can unmute yourself if you want. I hope you're not off of here. Were you exempt from AB 1482? Because if you were exempt from AB 1482 and you gave them notice that the owner wanted the house back, then there is nothing for them being displaced. I'm sorry, they're barking up the wrong tree, and it's in San Bernardino. Tell them to kick rocks with open-toed shoes. No joke. I mean, it's a stretch. In LA, I'd be squeezing my cheeks, but in San Bernardino and Riverside all day long, baby. I'm not fearing it. Oh, hang on. I see you responded in text. If she is not home, what about my locksmith? Call your locksmith, have him meet you at the door and open the door for you. You don't have a mic. I got you. Hang on. Val, if she's not home, you let yourself in. Call a locksmith and have him open the door. Don't change the lock, but have him unlock the door for you. You have every right to enter unless they tell you you can't. And if they tell you you can't, you're going to call the cops and enter anyway. It's in the original lease. You don't have a mic. Now I got to go backwards, Roadrunner. Hang on. It's in the original lease. Go back to Roadrunner. Hang on. It's in the original lease. Then kick rocks with open-toed shoes. I'm sorry that you're unhappy that you were displaced, but you did rent a home, a single family residence, exempt from rent control and any tenant protections. I guess, yeah, I don't want to say what's about to come out of my mouth next because it wasn't good, folks. I'm trying to put my filter on, but your tenant's reaching for straws, and that may work for them in LA, but it's not going to work in San Bernardino. Thanks for playing the game. I'm sorry you feel that way. You have a right to file a lawsuit, would have been my answer, but we also don't want to encourage them to do that. But it's a stretch. It's a big stretch for them. I don't see that as coming about. Don't worry. Don't lose any sleep. Hi, Widget. Hi, Victor. Quick question. You mentioned that as of January 1, landlords are required to provide residents with residential appliances, blah, blah, blah. I never said anything about an air conditioner, Victor. An air conditioner did not come out of my mouth. And is that an addendum from you or AGLA that will need to be on file? Is this required, acceptable to all properties, or only renewed for all residential dwellings? Okay. And what it is as of January 1st, we have to provide all appliances. Well, if the tenants are using their own and they want to continue to use their own, I want an addendum on file because this is law. So this isn't just talking anymore. This is something in writing. I want an addendum on file that says the tenant wishes to use their own at this time. I will have an addendum available both on my website, and AGLA's going to have it to help you guys, but they're pretty simple addendums. We just need to have them on file and signed on or before January 1st.
But it also sucks because the law says they can, like, I think on 30 days or something, just demand that you start providing an appliance for them.
Exactly. And that's
gonna
what I was
happen
going to
is
tell you. If their
Smart
appliance
people,
takes
when their thing breaks or needs repair, they're just going to demand that you buy them one.
Exactly. So instead of looking at it that way, look at it this way. If you have 200 doors, at least I'm not telling you to go buy 200 refrigerators in the next 60 days. I mean, we're going to have to provide it. If their refrigerator breaks, we're going to have to provide them with a new one. But it's better, in my opinion, of us doing it that way and trickling in the expense rather than just being inundated with the expense. Okay? So if they're on a month to month, we need the addendum signed on or before January 1st in order to cover your asset. If
Should
they're
have been
new,
able to raise the rent. Like, they should have exempted, made it not part of rent control or something if you have to pay for this. Otherwise, it's like a taking. It really is. I mean, imagine if you have thousands of units and all of a sudden, like, your gonna have to buy.
Just use a solid number like 100 doors. How much is a new refrigerator? $1,000? Holy shit, that just got expensive. And that's just for the fridge.
Hey, Patty.
Yes.
Over the weekend, I was listening to a webinar and they were saying that that the law is for only new tenancies.
That's not correct.
Okay.
No,
Absolutely not
it said
correct.
renewals. I looked at it like last week. It said new tenancies, but also any renewals after January 1st.
Yeah,
New tenancy.
renewals. And so they were suggesting not to renew a lease, to just go month to month. So that it wouldn't count.
Hold on. A month-to-month agreement renews monthly. That's a lease renewal. Chris, do you agree with me?
Yeah, the second month it would be a renewal. So
Bingo. So unfortunately, you got incorrect information, in my opinion.
Okay, that's why I'm checking.
There's a lot of that out there. It's okay. But in my brain, the way my brain works, a month-to-month tenancy renews every month. So on a renewal, we would have to, I want it on file by January 1 is the easiest way that I could explain it to anybody that has a tenant that wants to continue to use their own appliance at this time.
technically, you don't actually need that until you renew.
And if I'm on a month-to-month, I renew on January 1st.
Right. If you're on a month to month, you need it December 31st.
Dingo.
But if you're like a lot of us and you're on like a term of a year, you don't really need to. It's just something else to worry about at least renewal, along with the what is it, like 5 other things I got to give them in LA City now?
Yeah, right to counsel, how to wipe your butt. I'm sorry, did I say that out loud? Patty, I have a rental applicant that has income from a disability. He will receive until March of 2026 and meets the FICO score. However, I don't know if I should approve the applicant or how to let them know they don't approve. I have a rental applicant that has income from disability that he will receive. He's income qualified right now.
He's income qualified in March 2026, so arguably he's not income qualified right now. And actually, if you take him, you're kind of.
Oh, hold on. He is not. I misinterpreted this incorrectly. Hold on. Do we say that he has income that's coming on March of 2026, or is he currently receiving income that ends on March of 2026?
Hi, Patty. It ends March 2026.
Okay, so let me stop right there and let me help you retrain your brain, okay? He has income and meets our requirements right now. Whatever happens in the future, my crystal ball's broken. You can't deny him on something that may or may not happen in the future. If he meets your criteria today and he has income today, then he is applying today.
Okay. I was just worried because he has a disability, and what if he doesn't pay? Will it be harder to convict them?
What if it goes permanent by then and he's on permanent disability? You see what I mean? What if he wins a lotto on Saturday? Anything can happen. If they meet your criteria right now and you want to deny them, that's where you get into a discrimination issue.
Look into the references. Look into the references, like with a fine-tooth comb, and look for an excuse if you're worried about it.
It's a first-time rental, he told me, and he said he does have a co-signer that has good credit, so that's why I was kind of hesitant. It's for a family. It's 2 adults and 1 child for a 1-bedroom.
I would encourage the guarantor at this point. We don't deal with co-signers.
Okay, guarantor, correct.
And it's very important that when I speak back to you guys, I just correct with the terminology because we're trying to create good habits everywhere. Okay.
Perfect. And it's been empty for a long time now. So
You may want to bend a little bit because we're going to see a lot more of that with the state of the economy. And you guys can't say, Patty, what are you talking about the state of the economy? We just lowered the federal interest rate again. You guys paying attention? They're lowering interest rates. They're trying to get people to buy loans. Does that make sense?
Also, there's also been a lot of corporate layoffs, and
There's a lot of
all over the
changes
place,
going
so.
on. Yes. So if they meet your criteria now, you need to approve them now to avoid discrimination. Victor, I have a Section 8 tenant whose unit was inspected annually by the Housing Authority. However, every time I ask her to address an issue or we disagree, she reports me to the city without notifying me about the issues. And then the city conducts its own inspection, even though Section 8 already inspects the unit each year. Is this normal or allowed? Yes, it is. And you will have a litigious tenant. Okay. I thought that if housing authority inspects the unit, the city wouldn't conduct separate inspections. That's not true. Additionally, the tenant's partner or wife has moved in, and I have already sent an application and a reminder requesting her information, but the tenant hasn't complied. They got married. Husband, wife, husband. I don't care. It doesn't matter. What happens behind closed doors is nobody's business. Here's what you need to know. Once there is a partner, a marital status is a protected class in the state of California. So why they're boyfriend and girlfriend, girlfriend and girlfriend, whatever it is, they're not protected. The second they become married, they are to be treated as one. So you can kindly ask them for the information, but the reality is I'd be asking for the marriage certificate. Otherwise, it's an unauthorized occupant. Once you have the marriage certificate, now you know the name and all the rest of it can fall into play. I know you guys are big and adamant on getting applications so that you can see the social security number and see the driver's license number and you can see all this information. But if you have a legal document with that person's name on it, like the marriage certificate, that name is what you need to do a skip trace. Remember, I've worked in a collection company before, so I know how much little information you need to skip trace somebody to get their social, to get their driver's license number, to get all their information, an asset check, all of that. It is extremely simple if you have a legal document with their full name on it, and roughly a date of birth helps. How old are they? Okay, so what I'm trying to say is they're a protected class. You treat them as one. Oh, your wife has moved in. I need to see your marriage certificate. Bingo, there's a legal document with names on it you need a copy of. And now you're just going to add their name to the contract. That's all. Keep it simple. One of them has been living there the entire time paying the rent. So adding someone else is just someone else for you to go after later.
Right, but you can't really add them until you renew, right?
It just depends on what you got going on. But at this point, they're
really
saying that they moved. Hold on. At this point, they're saying that they moved someone into the property and they've married this person. Whoa.
Right, but they have a right to.
I need to see the marriage certificate and then we'll add them to the lease. No problem. Because as soon as I have that legal name, that's all I'm after on a legal document. But
but I mean, like, they're not going to, most people aren't going to sign that they're joint and severally liable, like the typical two-person lease occupants.
Exactly. Some of them think you're going to run the credit and their spouse doesn't have good credit. Now you're going to tell them that their new spouse can't live there. And you can't do that, but it scares them. It intimidates them. So you want to ease the situation a little bit better. Oh, congratulations. I'm so glad to hear that you got married. If you give me a copy of your marriage certificate, I'd be more than happy to add your new spouse to the lease. Okay, so that's how I handle that.
You can't really force them either. Right?
You can't.
You can't force them.
Congratulate them, be nice as pie about it, even send them a gift. I mean, I'm just saying, but you need to see that marriage certificate. That will tell you everything you need to know. And then you don't have to be, give me the application, give me this, gimme, because all we need is their legal name on a document and we're good to go.
I have a question actually that I hadn't thought of, or that I keep forgetting to ask about. And
Okay, fire away.
you know, you're going to say go read your lease, but do you remember if on a CAA lease with a parking addendum, if they're required to give you their license plate and car make and model and all that kind of stuff?
They are under the parking addendum to give you the make, model, and license plate of the vehicles that will be on the property.
Well, that's going to use the authorized parking spot or whatever.
Bingo. Yes.
So I mean, I want it, right, in case there's an emergency or somebody else parks there or whatever.
The reality is, all we really need, and mind you, just hear me out, okay? I don't care about that. You know what I'm looking at? If I can garnish your wages when you vacate. That's where I can't control a lot of what happens at Hello. I can't.
No, I know. The only reason is
life
because
events,
this
but I
isn't
can't control it goodbye.
this isn't a condo situation, so it has in the past involved other neighbors, and
I get you.
The parking has been an issue. So
I understand. So it is in
if they started blocking somebody, or if a car that was parked there, I would at least be like, well, this isn't the car you told me you're going to park here, or
right. I'm sorry,
or
it
I
wasn't
might have
on
some
your
idea that
wasn't on your parking agreement, so I had it towed.
right. Or I, you know, that I might not. I kind of want the ability to do that, but also like would know whether or not it's actually my tenants, or maybe some other pain in the butt is parking there occasionally and blocking the neighbors from getting in and out of the neighbor's spot. So
Right.
anyway, so it feels like I should push a little hard and get it and cite the lease and whatever.
Yeah. You
I
can
like asked for
absolutely
it.
tell them that in
I asked
multifamily.
for it before, and it was one of those things that they just kind of like, you know, forgot to follow up on, and I didn't push it too hard.
Not a problem, but it is definitely something that we do, especially in multifamily communities where we really monitor parking, especially in areas with parking restrictions, like places that are hard to find parking, like Santa Monica and stuff like that. Roadrunner, can I send them your shirt as the answer? Yes, you can. Sorry. When Steve Hilton wins, can we reverse this freaking crap? I can't answer that. I don't know, but I sure hope so. Rent-wise. Hi, Patty. I recently processed a Section 8 rental application with LA County. And please know that I am translating the shorthand, okay? And they claim they can automatically factor AC into the tenant's calculation of their portion. This basically lowers the owner's rent. Did LA County pass a new law regarding AC being mandatory? In some instances, yes. In other instances, no. And I would let them know, I'm sorry, this is what the rent is. April, are you on here?
Yeah, I am.
I love you.
Hi.
Help me out here with letting them know, if I list my house for rent for $5,000 a month and they have a Section 8 voucher for $4,800, I would have to lower my rent if I want to keep them as Section 8 is what they fight for, right?
If they don't have enough income for the full 5,000, yes, you would need to lower it.
In order to go Section 8, but I'm not required by law to lower my rent to facilitate their program.
No, you're not. No.
There's the key, folks.
But this question, okay, so I submitted a RTA, which is a request for tenancy approval on behalf of the owner. And LA County does it a little different from, you know, every housing authority is a little different. So what LA County is saying, so the owner is asking for the voucher payment standard. I can't remember what it is off the top of my head, but they were asking for the voucher payment standard. And I was questioning why it was reduced by maybe about $18. But, you know, I'm looking at every penny. Why is it reduced $18? And so what they said is that their housing authority automatically adds air conditioning in and factors it in just because that's what they do. So I went and found some, you know, HUD documents and blah, blah, blah. So they disputed it. But basically what it all came down to is LA County told me to take it or leave it. But I don't believe it's exactly. And I'm a woosah on that. I don't believe it's legal, but HUD is closed right now until further notice. So it's nowhere to go on that. But I was just wondering if LA County passed some, like, because I know that the temperature is supposed to be a certain degree or whatever. And I wanted to know if LA County passed a law recently that made something about air conditioning mandatory or something to give, maybe that gave LA County the gall to just implement this additional $18 fee to most landlords, and most landlords don't even know.
Okay, so what I just got out of everything that you said is most landlords are being deducted $18 if they don't provide an air conditioning system under certain housing programs.
Yes. Okay.
Okay, that's what I heard from you, because I got to simplify it for everybody else. But I understood exactly what you said, girlfriend.
Okay. Thank you.
To the best of my knowledge, there is no ordinance within the county that says AC is a requirement.
Okay. I knew it. I just wanted to bounce that idea off of you. But,
It's coming. It's a matter of when, not if, but it's coming. My guess is they're going to force us to by 2028.
Yeah, I'm gonna take it to the board of supervisors as soon as I get a break in my schedule.
As soon as they open.
Well, no, the board of supervisor, they have their meetings. It's just HUD. HUD is the federal government. They're closed right now. But the LA County Board of Supervisors is open.
I got you. I'm being funny. But yeah, I do some checking on that. I don't know of any ordinances. Now, some municipalities have an ordinance stating that AC is a habitability issue. Let me give you an example, okay? In the city of Palm Springs, if the AC goes out, it's a habitability issue and the tenant doesn't owe rent until it's corrected. But it doesn't mean you have to provide it in a house. Does that make sense? If it doesn't have AC, then it doesn't have AC. But AC is a habitability issue in the city of Needles, in the city of Barstow, in the city of Palm Springs, in the city of Palmdale, in the city of Lancaster, and there may be more that I'm unaware of. What that means is if the air conditioner that's already in the house breaks, you have to fix it. The tenant doesn't owe rent until it's fixed. But it doesn't say that you have to provide an air conditioner if you don't have one already. I hope that made sense.
It does, Patty. And I just think that with my experience with LA County and with most government agencies, is I think that the person maybe misinterpreted the regulation. And I hope it's not a blanket issue across LA County, because I had explained to the supervisor, you're nickel and diamond owners and you're making you're saving a lot of money off the back of the landlords with this $18 with all the contracts that you got, and $18 is what you're charging each one. That's a lot of money that you're pocketing and it's costing us. Anyway, I'm done I'm off my soapbox.
She's like, rant over. Okay. Next rant. Hi, Patty. If you deduct $125 or less from the security deposit, does that mean you don't have to give receipts? Yes, but you need to understand something, because people mess this up all the flipping time. Okay. Well, your cleaning bill was $120 and you left a water bill for $75. And you had a trash bill you didn't pay for $50. Am I over $125? I absolutely am. Okay. So if everything that you're deducting is $125 or less, you don't have to provide receipts. It doesn't mean if each invoice is $125 or less, you don't have to provide receipts. No, it means if they have $1,125 security deposit and you're taking out $125 and giving them back $1,000, you don't have to provide receipts. Okay. If you're charging $126, you have to provide receipts. All right. Anybody else have anything? Otherwise, I'm on my way to LA. Live at Agla tomorrow. If you guys need me, feel free to come down there. You could bring me lunch. Just kidding. Yeah, live tomorrow, Agla. I'm trying to think what else is going on. Hi, what you got?
I ask you questions about this all the time, but I have somebody that smokes in the unit in Montebello, LA County, and the neighbors complaining. I'm not sure, do I have to do like a 3-day notice?
Yeah, it's a curable breach of covenant because you have no smoking on the rental contract, correct?
Yes.
So give them a 3-day cure or quit to stop smoking within the unit. And I'd also add on the cure or quit that they're affecting the right to neighboring residents, quiet enjoyment by smoking in the property. There's several complaints.
Okay, perfect.
And then I'd send maintenance over there to change their AC filter.
Right. If they had one.
Wait, say it again?
They don't have AC in there.
You know the heat exchange filter?
Oh, the heat, yeah.
Go change the filter immediately.
Okay.
Have them write the date on the corner of it with a Sharpie.
Perfect.
Go back in 30 days and do it again.
Perfect. Thank you.
Are you paying attention?
Yes.
Okay. It's the witchy way. Yes, and check the smoke detectors. Check the CO2 detectors. But change the AC filter. Put the date on it with a Sharpie marker in the corner and the agent's initials that installed it.
Perfect.
Have them go back in 30 days and put in a new one. And when they take that old one out, it should go right into a hefty trash bag. Okay?
Sounds good.
That's how you catch them. Dates and initials on the filters.
Does that
Everybody else is
mean
like, wait, what?
does that mean you're anticipating bringing those into court, Patty?
I have before.
Okay. That's what I thought, but
I've taken dog. Then I got to choose my words carefully. I had to replace carpet in a house once, okay? And it was horrific. And I knew that these tenants were going to come back at me. I knew it. When you know, you know. When you know it's going to be heavily litigated, you know it's. So if you know that they're going to challenge everything you do, line up your ducks, right? I knew I was going to get challenged on this. Their dog peed all over the place. It was horrible. It was brand new plush carpet, 1.5-inch padding, very upscale. So when they moved out, I not only kept a corner and I had it all on video. So I walk in the house, cut a strip of carpet, pull it up, hold it up, show the backing of the carpet, and then cut a square out, put it in a Ziploc bag on the video, took the Ziploc bag into court. Only I had to put it in 4 Ziplocs. And I told the judge, you can open that if you'd like to, Your Honor, but I don't suggest it. I had a drawer in my office called Things Found in Toilets. No joke. And it would be a pen, like a Bic pen, and the date and the address in a Ziploc bag of what house the toilet. That way, if I was ever challenged, I could show up in court with, you know, the little angel figurine you had on the back of your toilet that fell in your toilet. We now call the poop angel because it cost you $1,100. Yeah, I'm going to take that poop angel and I'm going to carry it into court. I'm that girl. If my plumber's telling me I pulled G.I. Joe out of the toilet, bring me G.I. Joe. Put him in a Ziploc and bring me G.I. Joe. Because if I get into a court battle, I want to have as much evidence as I can have. I do not keep a gargantuan piece of the carpet. I keep a square. If I can't fit it in my purse, I don't keep it. Okay? When you deal with a plethora of properties, you have more than one drawer of things found in toilets. But it's a great tool to have when you go into court and they want to start arguing with you and you're like, Your Honor, I actually brought the carpet and the padding in for you today. Have a whiff. Let me know. I mean, some of the things that tenants put us through of trials and tribulations, we know what we're going to be up against when we get into court. We know that they're going to challenge us until the cows come home. So bring the cows with you. I know it's weird. I know it's obscure, but so am I. All right. Well, I did make Gabby laugh, but okay. Anybody else have anything? Otherwise, I'll end this for today. And I'm going to wish you all a happy Halloween. Patti, do you know about city net nonprofit that places homeless tenants into the home of landlords? Carmen, I'm going to explain something to you, okay? And I need everybody else to listen to understand. You're talking about a program, a nonprofit program, okay? There's a lot of them out there. Apparently, they got grants from the federal government to help with homelessness, to get the homelessness off the streets. So a lot of people open nonprofits, called them various things to help get the homeless off the street. And they're absolutely correct in what they're telling you. They will pay the deposit and they will pay the rent until their nonprofit runs out of money. And then what? Not to mention, you have a homeless person living in your property. Are they bringing in cans, aluminum cans? Are there now a bunch of grocery carts in front of your door? Have they broke that mental cycle of the homelessness versus housing? Does that make sense? Brilliant Corners and a bunch of these other programs that are out there are not federally funded. Federally funded is going to be Section 8. With that said, stay away from those programs. Okay? I'm sorry. We only allow third-party payments for existing tenants unless they're federally funded programs. I'm sorry. We only accept federally funded programs. Why am I telling you this? Because it's a law. We have to accept federally funded programs. That would be your Section 8, your VASH. We don't have to accept these mom and pop nonprofits that are most likely going to run out of funding. Make sense? Here, let me give you one. Had a tenant wanted to move into a property through Brilliant Corners. Brilliant Corners paid the first month's rent and security deposit. This person was homeless. This is in a multifamily community with over 60 doors. Okay? 3 o'clock in the morning, this new resident starts knocking on people's doors with an 11-inch butcher knife. I have it on video. Took him off the streets, put him in a multifamily community. The mental issue. Okay? That's the nicest way I can say that. But I see it all the time. Oh, I went with this housing provider and they put these people in and now they're hoarding cans and they have a bunch of other homeless people coming in. What did you think was going to happen? You got to understand, homelessness is like a community, kind of like us being a community of landlords. We're all going to help each other, right? Right? That's what we do. Oh, didn't think about it that way, did we? Sorry, didn't mean to ruin it. Correction, is it okay to record applicants during the screening process? You're scaring me. You don't see applicants during the screening process. You're looking at their credit report, running their credit. Do you mean at a viewing, at a showing? Is it okay to record an applicant?
Yes.
Or
Yes.
a prospect, because they're not an applicant at that point. Yeah,
Yes,
you can tell them that you're, I'm sorry, I have to record for my own safety.
And so recording the viewing and recording, I'm thinking conversations, because what I've seen is that they'll say one thing and then legally say something else. And
I understand, and that becomes hearsay. It depends on what you have in writing.
Okay. Okay. All right.
Remember, courts are getting better with video. They're now actually allowing us to show videos from our phones. They didn't used to do that. Okay?
Okay.
And it can still be argued, but what's in writing is what matters, in my opinion.
Okay, but I'm just saying, for telephone conversations, is it okay to record it with their permission? Like saying you call me with some.
Letting you know that this call is being recorded for quality purposes.
Okay, wonderful. Thank you.
I'm letting you know that this viewing will be recorded for my own safety. In other words, I'm in a vacant house with a bunch of strangers. I'm going to record this, but it's for my own safety.
Technically, I'm not sure you would even need to for video. It's the audio portion that the wiretap stuff usually covers. At least federally.
I got you. I went
And
to
California is a two-party state, so you do have to get people's permission.
Well, check this out. I went to a Cash for Keys one day and the people go, "She's recording." And I said, "Yeah, I'm recording for my own protection." And they go, "Well, I didn't consent for you to record me." And I said, "Well, I'm not recording you. I'm recording me for my own protection. Now we're going to continue with the Cash for Keys, or do we have a problem?" So sometimes it's just refocus. We're here so I can give you money. I have 40 grand cash on me, okay? I'm videotaping this for my own safety. So it just depends on what you're doing too. Sometimes you need to be a little bit more aggressive if you're standing there with 40 grand cash in your pocket and telling them, "I'm recording this for my own safety," and they don't agree, I'm leaving.
Patty, can't you also say this is my personal property and I have the right to do so?
Yes, well, Roadrunner's on here, okay? Anytime they call me, and it tells me before they answer, when hi, this Widget, or hey, how can I help you? I hear this call is being recorded for quality purposes. So I already know I'm being recorded and they're calling me. Okay? So that is completely acceptable, but you have to announce this call is being recorded for quality purposes. Or for training purposes. Are landlords supposed to sign up for a home title lock for scam protection of the property? If somebody's trying to get you to sign up to protect your title, run away from them. Okay? There's some scams going on, Carmen, and I know your concerns, and I know what you've just been handed. Okay? Carmen's been handed a little bit of a mess. Unfortunately, she lost her spouse and she's got a little bit of a cleanup to do. But at this point, don't spend any money with somebody trying to tell you that they're going to lock your title and save it from being stolen out from under you. It's a quick cash scheme. We have a lot of AI technology, artificial intelligence out there that is creating apps and programs and all this stuff for you. Go with what you know, talk to real people. This AI stuff is making accounting software for property managers, and it's just popping up out of the blue everywhere. And it's so not dialed in. It is so left field. Be cautious, okay? Please be cautious. And thank you for asking questions. We're all here to help you.
In California now, the recorder's office, when you record something new, will send like a little fraud warning to the last that like recording requested by in the upper left-hand corner.
Yes.
They send it. They're now like there's a fraud fee actually when you record any document. So they're now sending like a little notice.
So if any of you get a postcard or a letter stating that titles recently changed, you need to pay
it won't
attention
necessarily
to that.
say titles changed, but it might say I think it tells you that like a new document was recorded or something.
Well, exactly. Anyway. But yeah, it's giving you a heads up.
If you're not expecting like a reconveyance from the bank or something like that, and you're getting something new recorded, like that's the first step in the fraud is trying to put somebody else on the name of the title so they can then take a mortgage out. So
Whatever.
That's what you really want to watch out for. And at least in California, it's kind of that's helped to address it a lot. But other states, not as much.
There you go. Anybody else have anything? Otherwise, I'm going to get off of here for today.
Bye, Patty.
Hello. All right, you guys have a great week. If there's anything I can do, feel free to call me. I'm at Agla tomorrow. If you need me, you can call me there or even come see me. But if you come see me, bring me lunch.
Bye, Patty.
All right, you guys. I love you lots. I'll see you next week. Have a great day. Bye.
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 Happy Halloween.